Welcome to our webinar today about the patentability of AI-driven invention and the push for the legislator to play catch-up. The event is organized by the European American Chamber of Commerce, New York, and my name is Yvonne Bendinger-Rothschild. I'm the Executive Director, and I will be your host for today's event. To make this program interactive, please be sure to ask questions. We will submit them to the moderator throughout the conversation. Artificial intelligence is used more and more to develop new inventions, supposedly without human aid. And I'm already pre-setting the conversation here a little bit. But as AI capabilities increase, patent offices and business leaders around the world face a changing landscape. We will look today at AI's effect on commerce, including research and development, IP, and the regulatory framework that governs it. We will address issues such as how various countries are handling AI invention or AI-driven invention, how corporations are using AI and navigating IP implications, and how the World Intellectual Property Organization is tackling the policy and practical issues surrounding AI. Our speakers include Ryan Abbott. Ryan is an AI patent guru and the author of The Reasonable Robot, Artificial Intelligence and the Law. He has published widely and on issues associated with life science, intellectual property, and legal, medical, and scientific journals, including the New York Times and other major media outlets. Denise Dambois is the Legal and Policy Officer at DG Growth, Internal Market, Industry, and Entrepreneurship at the European Commission. There, Denise is part of DG Growth's IP unit, which is the main unit at the Commission responsible for IP policy. Philip Hishorn is a partner at Pane Schwarze, and he specializes in patent litigation and IP proceedings, including post-grant proceedings before the Patent Trial and Appeals Board at the USPTO. And we also have Krishna Sood. She's the Senior Technology and IP and Data Lawyer at Microsoft's Open Innovation Team and the lead architect of the Data Innovation Practice, empowering Microsoft's business groups. And she develops and executes together with her team, on the global data innovation strategy of Microsoft. With that, I hand over to Phil, who's going to moderate our discussion. Thank you. Over to you, Phil.
Hey, thank you, Yvonne. And I'm really glad to be part of this panel today. I thank the EACC and for everybody who's participating today by video. It's great. We have a great panel, and I'm glad that the introductions were already done, so I don't have to do them. But when everybody speaks, I think we're going to also tell a little more about ourselves and why we're interested in this topic. And I became more interested in it, I'll tell you, mostly because I was on a panel with Ryan and Krishna at one point in time, dealing with the same topic, and I just found it fascinating and have kept up with it ever since. I've watched it from the United States perspective, in the United States Patent Office and in the United States courts. So that's kind of my take on where this all comes from. And what we want to do today is kind of set the stage a little bit to talk about what AI is, what artificial intelligence is in this context. It gives some examples and things like that. And then talk a little bit about the IP policy issues associated with it, whether they are patent issues and patentability issues, whether we're talking about inventors and inventorship, or whether we're talking about actually how AI can use large data sets and some of the issues and policy implications associated with large data sets. And so Krishna really has an organization that has, among many other things, very large data sets that they hold for other people. And so we'll talk about some of the complications that can give to a business like Microsoft, but also to Microsoft's customers and how that data can be used as part of AI. So we'll talk about a lot of that. AI, what is it? And we'll have Ryan talk in a little bit about kind of really what it is, and then some of the things that he's been doing related to artificial intelligence on the regulatory side, to some extent, the patent offices and what an inventor is. What is AI used for? It's used for drug discovery. It's used for confirmation, building engineering, better engineering, better medical devices, data mining of various sorts, the self-driving cars that we see, the Roomba that kind of goes around your room and does vacuuming, all these different things, and really building better mousetraps. And it's, you know, in some cases it's self-storage containers and things like that. And the question is, how does that happen? How is AI used for that? What are some of the different types of AI? You know, how close to mimicking human intelligence are they? And what happens when they have an idea and then an invention? And so we'll talk a little bit about that. Many of the companies that we work with in the United States, that we work with overseas, have AI as part of their fundamental research effort. And the question then becomes, at least in part, if inventions come out of the work associated with using that AI, who was the inventor? And Ryan will address a lot of that. The other issues are really going to be, how do I protect my inventions if I am a company that's doing research in this area? And then why does this all matter? Why do we kind of worry about what AI can be used for and some of the data sets and data issues that are there? So I'm going to start out about some of the challenges to companies with Ryan, giving some background a little bit on AI. He is obviously published in this. He speaks on it all the time, is a world recognized authority, and that's one of the reasons he's here today. And he's entertaining, I will tell you that. So Ryan, let me just ask you, if you could, just give a little bit of background on what AI is, some of its applications and uses, and then we'll talk a little bit about the inventorship issues associated with AI.
Well, thank you, Philip. That was genuinely an overly generous introduction, but I still appreciate it. And I'm going to Venmo you for that later. You know, it's interesting. I do talk about this all the time, and half the time when people get in a room, they want to talk about what AI is as a definition. And amazingly, 60 years after the term got tossed out, people still can't agree on what AI is, including in a lot of regulatory efforts going on right now. You know, to me, I see AI as basically an algorithm or machine that does something you'd associate with cognitive abilities, right? So something a person would do, something you'd look at and think, well, this is intelligent. Of course, a lot of people define artificial intelligence by reference to intelligence, which my elementary school teacher told me I wasn't supposed to do, but it still happens. You know, the gist of it is that you have machines doing things that you used to just have people doing. And that can be simple things like operating a cash register at a McDonald's, to moderately complex things like driving an Uber around a city, to stepping into the shoes of human scientists, doctors, and lawyers and doing some of the things that those people used to do, like automating contract drafting and discovery, or they have an FDA-approved device now to autonomously diagnose macular degeneration, or to find a novel vaccine candidate.
Okay, and so let's talk a little bit about some of the novel uses. And I use novel in the sense of really in the patent world, and the idea that you need novelty to have an invention. You need to have not have prior art that kind of reads on it. So the type of novelty that you're talking about with artificial intelligence systems, and we can talk about the example of like the macular degeneration. How does the AI function? How does it, you know, not necessarily in that specific example, but what is it doing? And, you know, for somebody who is more of a layperson, doesn't really do computer programming, doesn't understand that, how would you say the AI operates, and what is it that the scientist or the researcher is doing to implement that usage?
Sure. And it is a little complicated. You know, a lot of the recent breakthroughs in artificial intelligence have involved something called machine learning, which, you know, there's a lot of ways to build an AI. Some of them is you pre-program them with rules, often from experts, like, you know, if I'm visually looking at a mole on someone's skin, if it's larger than 5 centimeters, that's a warning sign. You know, other times, you know, with machine learning, you basically show an AI a million pictures of moles. You show the AI whether they were melanoma or not, and the AI developed some complex rule for figuring out when a mole looks like it might be melanoma, sometimes in ways that aren't really describable to people or that don't reduce to simple rules. And some people do want to get into how an AI functions and whether that's relevant to this sort of thing. Personally, I think that really all that matters is what an AI is functionally doing. Now, people have used AI and R&D forever, or for decades and decades, and it hasn't historically really automated the inventive process so much. It's a tool that you use to help do a very specific thing. But AI is getting more sophisticated and able to do more sorts of things these days, and people are turning more over to it. So, for example, Google published a paper in the journal Nature in June saying that they had developed an AI that could design a chip floor plan by itself, which is the design of a microchip, which is something that is protectable by IP rights. And they say a team of people take months to do this, and the AI can do it in 6 hours by itself and generate chips that are better than those that people made. So if you program an AI that can make a new chip floor plan, which is a protectable output, and they license it to Intel, and Intel has it churning out these valuable designs, what do we do about that?
So what do we do? And in a situation like that, where the AI effectively is making the step between input and an output that is something that we would consider to be novel, different, inventive, how do we deal with that when we go to something like the US Patent and Trademark Office, or we go to the European Patent Office, or we go to any nation state?
Right. Well, it's a good question, and it was, the motivating force behind this series of legal test cases I've been spearheading. I got interested in this working as a life science patent attorney, 8 years ago, when I saw some companies emerging that were saying, or, getting ready to say this was their sort of business model. It is now, there are now many companies that say that their AI is doing this sort of thing. And I was, thinking, well, what do we do about it? And I would speak on it, and people would think it was vaguely interesting. And, a few years later, companies were coming to me and saying, well, no, actually, what do we do about this? And I think, firstly, if you weren't doing a legal test case, one of the things that you do is you design an R&D process to make sure that there's a person in it who, if push comes to shove, you can say, did inventive work. That also might not be the most efficient way to structure something, though. I mean, if that Google AI really can make a better floor plan, a person in the middle of that might just screw the thing up and slow it down. And before our test cases, there really wasn't any law on this at all anywhere. There is law on copyright. In the UK, they explicitly protect this sort of thing by statute. If an AI makes a new commercially valuable song, it gets copyright protection, and the producer of the work is deemed the author, and it gets less protection. But there was really no case law on this anywhere. So, we did not have, and again, when we say the AI automated it, there's misconceptions sometimes that we're saying, and a general artificial intelligence woke up one day and decided to go invent something. This was very much a machine designed by people to invent things, but without someone who traditionally qualified as an inventor, because they didn't conceive of the machine's output, and recognizing the value of the output was done by the machine and required no further inventive skill by a person. So we filed an application designating the AI as the inventor because there was no human inventor and it functionally invented in 17 jurisdictions now. We listed the AI's owner as the patent owner. Of course, it's never been our argument that the AI should own any property. It can't, and that would also just be stupid. But people should own the output of their property, as we do with physical property through doctrines like first possession and accession. And we argue that's appropriate here as well. Different patent laws in different jurisdictions, may come out differently on this, but I'm not really aware of any that were written with this in mind. And it is our position that this is the sort of thing the law should accommodate, because machines don't care about patents, but companies like Microsoft care about patents. And if we're moving to a paradigm from incentivizing people to do things to incentivizing people to build AI that could do things better than people, we still need that incentive, especially in places like life sciences.
So yesterday you sent me at least one opinion. I think it was from the UK High Court, but maybe I've got the wrong court, but it was from the United Kingdom. And why don't you tell people what that was about? And it is one of those test cases that you were talking about.
Right. So we filed 2 patent applications that went to the UK and EPO first. We did not disclose an inventor there. You don't have to for 18 months. And they were substantively examined. The patent offices found they were new, inventive, and useful. And then we corrected the inventorship, and they were denied on that basis. They went 15 other places. In June, we had a patent granted in South Africa with the artificial intelligence listed as the inventor and Dr. Thaler, the AI's owner, as the owner of the patent. 3 days later, we had a decision from the Federal Court of Australia holding that same scenario should play out. That's being appealed. In the UK, just this week, we had a decision from the UK Court of Appeal that dismissed our appeal from the UK IPO, which denied the application, but it was a split decision. Justice Burse held that he would have allowed the appeal and say an inventor has to be a person, but that shouldn't stand in the way of getting a patent. You just wouldn't have to list an inventor, which was one of our alternate arguments. The real commercial imperative here is, can I get protection for things made by my machines, right? So maybe one solution is, well, if there's no human, you don't have to have an inventor. Of course, I'm not aware that a patent anywhere has been granted without an inventor. So, we listed the machine because it functionally invented. The European Patent Office has a hearing on our initial formalities denial in December, and they have suggested that maybe the approach to this is not to list an inventor as well. So we'll see what they say in December. It was also rejected from district court in the US. That was just appealed to the Federal Circuit. It was rejected in Germany. That's kind of endlessly bogged down in German appellate court, and everywhere else it's still pending. But also there's a couple jurisdictions like Israel, for example, doesn't require an inventor to be disclosed. And Cyprus and Monaco reported to EPO they don't require an inventor to be a natural person either.
And isn't one of the, as a patent lawyer, which is, when I'm out there doing patent litigation, that's what I do. We look for things about conception. And, it's that idea of conception and reduction to practice. And we're tied up in the language of our legal opinions of conception and what is conception and can AI have conception. I think that's part of, at least when I look at this, that's part of the problem, is not that it's wrong to have AI be the inventor, but that the way we have structured our legal system is such that we have individuals conceiving, and we have this very, whether it's a stroke of genius or flash of genius, but why can't AI have that? So Denise, I want to turn to you for a moment to talk a little bit about kind of the European side, although Ryan really does talk about both. But what are some of the IP policy issues that are bouncing around Europe related to AI?
Yes, good morning or good afternoon, everybody, depending on your locations. Well, in the EU as well as in the rest of the world, there has been and there is still considerable attention being paid to AI and to the IP aspects of AI. Of course, the EU is a quite complex animal, and as you may know, well, we have the European Patent Office, EPO, that plays a central role in terms of patenting for its 38 contracting states. But separately, because the EPO is not an institution of the European Union, and separately you have the institutions of the European Union, including the European Commission, where I belong to, which is capable of defining IP legislation. And just to take one example, that was back in '98, the European Union adopted this biotech directive proposed by the European Commission, clarifying the rules about the patentability of biotechnological inventions. So if there was a need, well, theoretically, both the EPO could decide to amend its own rules, either the European Patent Convention as such or the implementing rules of that convention, or the European Union could possibly adopt, for example, a directive harmonizing rules in that field. However, there is for the moment no intention of that nature. So both the EPO and also the European Commission, and I think most of the member states of the European Union, because of course they play a crucial in these processes of legislation definition, apparently there is no prevailing opinion that the rules need to be changed for the moment at least. One of the reasons possibly is that AI is still very much an emerging technology, and it may be a bit early to legislate, while this might have unintended effects in respect of future developments that are by definition still unknown. On the other hand, it seems that today we are not facing huge problems regarding the patenting of AI, meaning that, of course, these inventions are patentable per se. Now, of course, as it has been mentioned a few minutes ago, there are some sort of technical issues, like in connection with inventorship. And as Ryan just mentioned, indeed, the EPO has, for the moment, rejected these DABUS patent applications that are now under appeal. So let's see what will come out of it in December, indeed. But you may have seen, and that is not very usual, but it confirms that it is a very important and sensitive decision. For once, the legal board of appeal of the EPO has published in June a preliminary opinion on this DABUS case, considering, but very provisionally, that indeed, as you all know, according to the EPC, the board considers that inventors must be persons having a legal capacity, which appears to rule out AI systems as such. But again, this is only a provisional opinion for the moment. Let's see what will happen in December. And as Ryan also rightfully mentioned, it might happen that the board will decide that in certain cases there is actually no need to identify an inventor. So let's see what will happen. So that is a short summary of the state of play in the EU, while we are also actively participating in international discussions such as in WIPO, but I don't want to anticipate on future questions. Thank you.
Maybe I'll go right there then. But let's talk a little bit about some of the policy implications within Europe, which I think are going to be somewhat similar to what's happening in the United States. The problem, again, as a patent litigator, the problem comes down the road when the patent is issued and somebody is named as an inventor, but AI is really the creator, and in many ways comes up with whatever the invention is. So I push the button, the AI goes and does the work, and I'm named as the inventor. And the deposition comes in, and I am deposed, and I'm asked the question, are you the inventor? And the answer is, I'm named the inventor. And so to me, there is that break between being named the inventor and actually being an inventor, and the repercussions associated with that in litigation, which is maybe you're not entitled to a patent. But it sounds to me, at least the way most of the nation states are going right now, is that if you name somebody, we're kind of allowing that logical leap and just saying that you don't have to name the AI as the inventor. Instead, you just name the individual who pushed the button. And I don't know, and I kind of agree with Ryan, that it doesn't necessarily make sense that that's where you want to be. So I don't know is there any discussion from corporations about kind of using AI, but having a fear that some of their IP will become unprotectable because of this difference in inventorship?
Yes, I see that this can be an issue, and I know, for what I know about the United States, I know that these inventorship issues are being taken very seriously by the Patent Office and by courts, and that fraud in that respect can really have very serious consequences. In Europe, well, I think I'm not aware of any deep analysis of these issues, but my gut feeling, I would say, is that these inventorship issues in Europe maybe do not have exactly the same weight, the same crucial importance as in the USA. And I personally, I never heard about a patent being revoked in Europe due to an issue revolving around inventorship. It may have happened, but simply I'm not aware of that. But certainly this is an issue that deserves to be investigated, because it is very clear that we are aiming for maximum legal certainty. And so by using a sort of workarounds, by naming an inventor who actually played only a minor role in developing a certain invention, potentially this might create trouble. Although again, I have no evidence of that for the time being, but certainly this deserves a further examination.
And are there, turning to WIPO for a moment, have there been, at least as far as you know, kind of policy discussions around AI that WIPO has been looking at and thinking about, is there a need to address other regulatory and policy implications, whether it's kind of intellectual property protection, policies that should be put together in individual nation states, things like that?
Yes, indeed. At WIPO, and this is fortunate because, of course, it is clearly preferable and advisable to discuss these issues internationally, considering that discrepancies between different legislations in different continents and countries are rarely beneficial to the users and to our economies. But indeed, was it, yeah, in 2019, WIPO launched the so-called WIPO conversation on the intellectual property and artificial intelligence, which was a sort of very open, very wide forum, which until today had 3 meetings, if I'm not mistaken. And they started by publishing in December 19 so-called draft issues paper on IP policy and artificial intelligence, inviting all interested parties to submit comments. And this feedback led to a revised issues paper that you can find on the internet. It is publicly available. And what I find quite interesting is that it covers many IP rights, not only patents, but also copyright, data, trademarks, and many others. What we might regret, but okay, I understand they want to be cautious, so they are progressing step by step. But in this process, actually, if you look at this issues paper, this is just in a way a list of questions for further discussion. But well, one step at a time. I think it is quite good already if we can internationally agree on which are the relevant questions. Of course, the next step logically would be to collect answers to these questions from different jurisdictions, and then see where the gaps, where the discrepancies, and what could be done to overcome them. But okay, that will be the next step, and I'm not in charge of this WIPO process, but I certainly find it very positive and constructive, especially with this international context.
Okay, I want to turn a little bit to Krishna now, because I want to kind of move this to talk about some of the applications and some of the data-driven issues associated with AI. And Krishna, I know we've talked in the past that Microsoft, among other things that it does host data, very, very large data sets for its customers. And there are implications that those data sets can be used as the source, effectively the food for AI. And if you can give either Ryan or Krishna a little explanation about that, and tell us kind of what some of the IP and policy implications would be for somebody in Microsoft's position and potentially somebody in your customer's position when we're looking at kind of these large data sets as being the fodder for the AI that's being applied.
Sure, Phil, and thank you for having me, and hello to everyone, whether it's early in the morning or later in the evening. It's great to be here. I have my cup of coffee because it's early morning for me, so I thought we were just going to chat about the weather, Phil, but this is a much meatier topic. You know, it's a really interesting question because as everyone I think knows, in order to really power artificial intelligence, you need a couple of things, and I'm going to grossly simplify it, but you need investment, you need digital skills, so you need the talent to actually basically code and operate and train the AI, and you need a lot of data. And I think that there have been a lot of discussions, particularly both at the kind of the policy, the legal, and also actually just from a practitioner's perspective around, well, what happens to that data? What is the role of that data in both from an input perspective, but also from an output perspective? And it does, from a practitioner's perspective, it does raise a lot of interesting questions. I am going to take a little bit of a step back and actually just give kind of, I guess, a preview of Microsoft's general view on intellectual property law and how we do apply that in the data space. You know, from our perspective, I think it's really important to look at the objectives of IP law. And in the US, you know, it's enshrined in the Constitution that actually Congress is empowered to make laws for the progress of science and the useful arts. So it really is intended to incentivize innovation and really to incentivize the sharing of that innovation in the pursuit of progress. And so when we apply it to the data space, what we're really trying to, you know, identify is, are IP laws facilitating innovation, or are they being interpreted in a way which actually pose barriers to innovation? If, you know, when we survey the landscape, we don't actually see that there is a lack of activity in the AI space. There is a lot of activity in terms of companies, individuals, either engaging in machine learning, using AI and producing outputs. We can discuss later on whether we think that's protectable or not, and that will really vary on a case-by-case basis. But the biggest barrier to AI from our perspective is not necessarily the laws, it's actually the lack of digital skills, for example. I did mention data and you mentioned data, and that is something which Microsoft has through its own work, identified that there are certain countries that may hold more data just because they have companies or businesses or platforms that have more what we might call AI or data-driven companies, and Microsoft has launched an open data campaign specifically to address this, what we call a data divide. But I think it's really important to note that data, and particularly data ownership, and that is a term that's used, IP law may not be the appropriate lens to view data, right? So when you think about it from a personal data perspective, the corporation that holds that data doesn't own that data. That data is owned, if you like, by a data subject. And so there are mechanisms, particularly in Europe, there are mechanisms in place to ensure that companies have the appropriate mechanisms to obtain and use that data in a way that comports with the expectations of that data subject. Likewise, from a Microsoft's perspective, if we are holding commercially sensitive information of our customers, we don't own that data. We hold it almost like a custodian on behalf of our customer. And so we are very clear in that distinction. that we are holding data on behalf of if it's customer data, we are holding it basically on behalf of and processing it at the instructions of our customer. And that does restrict obviously what we can do with the data, but we think that that builds a more equitable system and actually a more sustainable system when we look at IP, particularly in this broader context of the role of IP to incentivize innovation. Of course, Microsoft is a company and it is part of our mission to innovate. It's also our mission, though, to empower customers to be able to achieve more. And so we try to strike that balance of enabling our customers to use the data and use our technology to actually empower them to achieve more.
Right, and I think that's one of the things that we've talked about in the past. And what I think is important is this idea of ownership, where you have servers and other things that have massive amounts of data, but they're not really, they're the data of the customer, or if it's medical data, maybe another step removed, that you may have situations where if we're looking at healthcare related issues, treatment related issues, and longevity between treatments and things like that, things that AI can inspect and can be used for its analysis, but those are not really things that Microsoft owns necessarily, but the customer does. And but being able to access it is just so important for AI, at least as I understand it. So I'm going to actually flip. There is a question from the audience, which I will throw out, I think, and basically anybody can answer this one. It's so the question is, the EU GDPR is leading the world in data ownership and use, while the USA lags as a slow and fragmented follower. And for those who are in the US, effectively California is leading the way in privacy rights compared to, say, I'm New York, New Jersey. We don't care as much. And could the EU do the same thing with AI as IP effort? It is a huge transatlantic opportunity if there were consistent AI as IP legal rights that were the same or at least similar in EU and USA. And they're looking for comments. So that's just, so there you go. That was the question. Go ahead, somebody.
I'm happy to talk on this. This is really Denise's space. Maybe we could both say something about it. I do get a sense there is a bit of an AI policy arms race going on right now, as there is an AI arms race and an industrial policy arms race. The European Commission has just published AI regulations, seeking really to be the leader in a global framework of AI regulations generally, in the way it did with GDPR. But also jurisdictions have very different values and attitudes towards this sort of thing. I mean, you said leading the way on privacy like it's a good thing, and it is a good thing. I think if you're European, people generally have similar sorts of attitudes. Other jurisdictions, place very different emphasis on, consumer privacy versus commercial rights. So, you do get a divide in the way that countries want to treat some of these issues. There was a European Parliament resolution last year that held that AI-generated invention should be patentable without discussing the inventorship issues. I think Denise is right. Inventorship really is a formalities issue, although in our cases, it has led to a substantive rejection, essentially, of our patents. So, whether or not these sort of things are protectable at all are a key part of industrial strategy and incentivizing AI. And I think the next few years are going to see some countries try and take the lead on this.
And Denise, I didn't know if you wanted to weigh in on that same question.
Yes, well, very little. I have very little to add because what Ryan said, of course, makes very much sense. And I would say, but I think I mentioned it already 10 or 20 minutes ago, that in about anything relating to IP law, it is, of course, preferable if we can achieve some global harmonization. And this is a process that started quite early. I think that the Paris Convention, the first international treaty about IP harmonization, dates back to 1883 or something like that. And it was only the second such international agreement. I think that the very first one was something about postal services, because they of course have a very clear international dimension. But so IP came second. That is quite remarkable. And since then, of course, we had other treaties, and WIPO was set up, and then WTO started to be involved in IP matters with the TRIPS agreement, etc. So this is all pointing at the same in the same direction, looking for some international harmonization. Of course, this is easier said than done, and progress has been a bit slow in recent years. Despite many attempts, whether it is about the substantive patent law treaty or others, it is getting more and more difficult, as it seems, to agree on some common rules internationally. But again, I can only hope, and we are ready to contribute to that effort as the EU, whether through together with the EPO, which is a very close and natural partner for us, and within all of these international fora, including in this WIPO conversation started 2 years ago that I just mentioned. Well, we are ready to contribute, but I see, and this is quite positive in my view. Of course, we have these decisions about ownership, which are different in Australia and South Africa compared to the US and Europe. So, of course, this is, I cannot say I'm happy about this divergence, but apart from that, I don't see many huge discrepancies, especially regarding the question whether AI-generated inventions are patentable or not. And this is, for me, the most fundamental question. And here, fortunately, again, I do not see any major discrepancies.
Okay. Well, I want to turn back to Krishna, and we were talking about different types of policies, but what types of additional IP or policy challenges do companies like Microsoft and its customers face other than kind of the patentability of artificial intelligence?
So that's a really great question, because I think Denise might have touched on it, that actually particularly when you're dealing with AI, there's obviously the patentability issue, but it raises issues related to copyright. It really raises issues, particularly if you're based in Europe with, say, databases and the database directive. It can raise issues related to trade secrets. And so it's actually really important to adopt a kind of a holistic view when looking at the legal issues. And then that's only on the IP side. There are a whole bunch of other issues outside of IP when you're dealing with data. And so I think it's really important to understand how the technology works, and really to understand what issues are actually implicated for that specific scenario. I think sometimes there may be a tendency to assume that the output may be copyright protected, but for example, say with machine learning, there is, from a copyright perspective, there is reproduction. So for example, I'm trying to train a model to read a specific text. I train the model with a specific text. There's a copying, so there's a reproduction, which is a copyright protected act. There's an output. If that output is very similar to the input, I would question whether that output is actually protectable, right? There may be a whole bunch of other issues with respect to infringement, but the point is that I think it's a leap to just assume that the output is protectable, and that's very true in the data space. So a common misconception, I think, is that I'm providing some data. I think it's valuable. It's being used to train a model. The output, I must have some interest or ownership or right in the output. And I'm going to take it back to, if you can think about to law school days when we all had to write research assignments and thesis. I can go to the library as a human. I may consume umpteen number of texts in order to write my thesis. the fact that I have read and digested and internalized a treatise on IP law does not mean that the author of that book has a right or can claim ownership in my thesis. I've taken that work, I've reasoned over it, and I've used it to come to my own conclusion. And it really is similar with machine learning and AI. Of course, there will be instances where perhaps that output may be protectable under a certain legal theory in IP law, and there may be instances where that output may also be infringing under a certain legal theory. But I think to just assume that the input equates to some interest in the output is probably not the sustainable way to think about this as we move into a world where there's just increasing, from our perspective, what we see is increasing activity in this space. And I will go back to my earlier point about the objective or the rationale for IP law. I think ultimately we want to democratize access to technologies to allow customers and individuals to innovate. And we want to democratize access to the data needed to feed and train those models. And so again, I kind of take a step back to I think you termed it in one of our conversations, a more utilitarian model of, are we creating policies to ensure that actually as a society we are progressing, and that it doesn't advantage a particular group or sector, but it enables innovation for everyone.
Okay. I think one of the things, there's another question from the audience. I'm going to go read that one out loud again, and we'll kind of talk about some of those same issues. Are there frameworks or mechanisms being proffered or put in place to bring up laws in various jurisdictions and on a global basis to accommodate AI? That's one question. The law being an instrument of social engineering should develop along with technology for technology to be applicable and useful. What is WIPO doing to bridge the gap? So assuming that there is a gap that's being bridged, and this can go to everybody, because I think the first question, are there frameworks or mechanisms being proffered or put in place to bring up laws in various jurisdictions and on a global basis to accommodate AI? Let's talk about that one first.
Sure. Well, I'll start it, I guess. I mean, I think that is right. The legal frameworks we have in place will affect how technology develops and how people will engage with technology and how it can be used and whether we're optimizing the social benefits we can get out of technologies like AI. So these legal frameworks are very important now. As to what people are doing, I think that there has been right now, including through the work of WIPO, really a multi-stakeholder dialogue about these issues, and in a way that they haven't previously. Governments and policymakers are thinking through these issues. But that process does not historically move quickly, right? Technology tends to move a lot faster than that. And nothing moves slower than creating a new international instrument. So I think to WIPO's credit in setting the scene for this, setting out issues, encouraging dialogue, this is the right sort of way to start a process. And I'll also say that it's been my observations, being at those first two WIPO conversations and doing some other things with WIPO, attitudes are shifting very quickly in this space, even now and among policymakers. India very recently had a parliamentary consultation that recommended that, and our applications are pending in India, there have been no actions on them, that the law just explicitly state that this sort of thing is protectable. It already is there in copyright, but that it also be made so in patents, and it already is, I think, in design too. That'll take probably a couple of years to play out in India, but I think that other jurisdictions now are looking at this in a more serious sort of way, are realizing that there is a need to provide certainty for businesses, because also you don't want a company investing in AI that can do this sort of thing with a decade of uncertainty of what your business model is and whether it can get protection and how you're going to license these things, with the threat of, well, maybe I'll get protection in Australia, but not the United States for this invention. Ultimately, the solution to that is, I think, an international instrument, because all sorts of weird things are going to happen if you have an AI industry developing in this direction where only some places get protection and some places don't. But that requires a lot of consensus, an international agreement, that is.
Yeah. And Denise, I don't know if you or Krishna, you have any more comment on that? Okay.
I mean, I will just say that I think I think there is actually a lot of activity in terms of legislating on AI. What we do see is that it's actually more on the on a jurisdictional basis. The EU is probably one of the regions which looks at things on a regional basis just because of the kind of the trading block that it is. But I will agree with Ryan that from a business perspective and even just from a research and data science perspective, legal certainty is really helpful when you're trying to spur innovation. Researchers will say to us, actually, we're just not going to use this data set because we don't know. We can't verify the pedigree. We don't know whether there are risks associated. So it actually, the legal uncertainty, put another way, legal uncertainty can actually cause paralysis, which is not helpful when you're trying to be an AI-driven, data-driven economy. So it's something for countries certainly to think about, jurisdictions, policymakers, legislators to think about, are we creating legal certainty that's going to achieve the objectives for innovation and derive economic benefit? And with that lens, hopefully, we could look towards an international instrument, but certainly there's a lot of activity on the national level. Sorry, Ryan, you were saying?
Oh, no, that's right. I just wanted to add one thought. I mean, and the other point is that it does matter a bit what jurisdiction you are. If we're looking 10, 20 years in the future and thinking that AI may start doing a lot more than it's doing at a much greater scale, not every country in the world will be churning out AI-generated music and artwork and inventions at the same level. And so, different jurisdictions also have different interests in that front.
Okay, we have some other questions from the audience, so I'll bump into the next one. A number of countries were mentioned as not requiring the inventor to be disclosed in patent applications. I think those were Israel, Monaco, and Cyprus. Can you explain why and any pros, cons that they don't require an inventor, and why those countries specifically?
Right.
Yeah, so go ahead, Ryan.
Yeah, so Cyprus and Monaco reported to EPO when they did a survey of member states on this that they didn't require an inventor to be a natural person. Israel is the only country I know of that does not require an inventor to be listed on an application. And there is a fair bit of law on an inventor being a natural person, which is generally, I would say, the international consensus. But this has only come up in the context of whether a corporation or something like a corporation could be an inventor, because if you're IBM, you don't really care who's listed as an inventor, you just want your patent. And I think a variety of reasons corporations haven't been allowed to be inventors are, one, corporations literally act through human agents. So if you didn't list, so there is always a human inventor when a company invents something. And if you didn't have to list an inventor, people would lose out on a lot of credit for work that they've done and sometimes economic benefits to it. So it protects the moral rights of inventors, and it also clarifies chain of title, which can work in complex ways, but is generally through employment obligations or assignment obligations. If you have an AI, though, doing something, it does not literally work through human agents. In fact, in what we're talking about, although someone told the machine to do something, there isn't a person who qualified as an inventor. So you don't have that same need to list someone who did something inventive. And we're alleging that the entitlement issue works a bit differently. But back to the corporate setting, it's a lot of work for anyone who's a patent attorney. It is a lot of work to find inventors, to get assignments, to get things in writing, to track them down. I suspect, although we are still looking into it, that Israel simply decided that a pragmatic approach was warranted. And this only comes up at the patent office if someone, intervenes in a proceeding and says, actually, I'm the inventor and I want to be listed, or actually, they're not entitled to that invention. It came from our lab, we should be entitled to it. I think that's why Israel did that, but that's a very old rule.
Okay. And I don't know, Denise, if you have any other comment on that.
No, actually, no. I'm not aware of these historical reasons that deserve certainly to be investigated. But again, in Europe and in some countries, as you may know, in France, in Germany, and in a few other countries, there is a specific legislation regarding employees' inventions. So there, of course, it is important to clearly identify the inventors, because actually they have rights, including possibly the right to an additional remuneration. But other than that, no comment.
So we're talking a lot about both AI and innovation, and those two things working together. And it's clear that it is, when you look at statistics, just using patent applications as a gauge, that we're seeing just a much greater number of AI patent applications of all sorts of different types. And I guess one of the questions that the audience is asking is, we've got about 5 minutes left, so we won't go too far, is how to handle IP rights of infringement by AI. And I guess what I may not quite understand the question perfectly, but my sense is, if AI is creating inventions that somehow now fall into an infringement area, how are we in the courts of whether it's Europe or the United States going to address kind of AI that's doing that, and what type of issues are going to be raised from that? If anybody has I don't know that I have an answer for that. So
yeah, very briefly, and again, it's a sort of gut feeling. For me, it doesn't seem to be a major issue, to the extent that it is not the AI system that will use the whatever has been generated, whether it is a new product, for example. Well, it is your company that may use an AI system to design a new product, but then it is the company as such, the factories, etc., that are going to manufacture the product and to put it on certain markets. And this is where the responsibility will be. Like even with a human inventor, well, a human inventor cannot be convicted for infringing any other patent. What could be convicted in court is a company for placing a certain product on the market. So again, for me, not a major issue, I would say.
I agree with Denise on that, but as I interpret that question a bit differently, as AI is doing more autonomously, will AI be engaging in sorts of things that are traditionally infringement? Like, is it pulling data from the website and making derivative works with it, and using it in a way that we don't normally let people use it? And I think that will come to be an issue. I don't think it's an unsolvable issue. I think really a lot of existing infringement, liability rules apply to this, as with just about any AI activity. As Denise says, the AI isn't going to be liable. The people making, using, or operating the AI are going to be liable in some sense. But this may implicate more complex rules of liability, like indirect liability and vicarious liability. Who programmed the AI to do what training data did it get, who instructed it to do what, and if it ultimately makes Avengers 4 without Disney's permission, to give the lawyer's answer, it'll depend who will be liable for that. But as with a self-driving car, the car's not liable, Uber will be liable, and so will the people behind the AI.
So let me ask quickly, Christian, do you have any last thoughts as we're in our last minute and 10 seconds or something?
I just on that point, I was going to agree actually that I think that the existing AI responsibility and liability framework, I think at this point in time extends to the scenario that's been put forward. And so, I would probably apply the same liability framework that exists, particularly under, I would say, copyright and kind of the areas that I am closer to, but Ryan's spoken to the patent framework.
Well, I think Yvonne's here to tell us that we are out of time. So it's been a wonderful panel, and I thank you all for your thoughts. And I hope the audience got something valuable out of it. I know I did. And Yvonne, I don't know if you have something else you need to say. Thank you all.
Thank you so much for the conversation. Really interesting panel, I have to say. I mean, I think we have to follow how this is developing with all of the inventions coming down the road. And Denise, if you can keep us posted if there are new regulatory updates, we will do a follow-up on this program. And speaking of programs, we have another interesting program coming up, Responsible Capitalism and how companies are integrating ESG into their operations, September 30th, so be sure to join us for that. And we have more programs in the pipeline. We will post them on the website, so make sure you go to the website, eaccny.com, and learn about our programs. And that concludes today's webinar. A big thank you to our panelists for sharing your insights. And a thank you to our audience for joining us for the discussion and for the many questions you sent. Quick reminder, we make a list of attendees available after the program. And if you're a member and would like to connect to any of the other participants, we're happy to facilitate that. Thank you to all and enjoy the rest of your day.